Our subscribers get it, with exclusive access to breaking news, briefs, reactions, opinion, and process. iPolitics. Are you up for it?
Okay, we're back with our second segment of this panel discussion on the CETA agreement with the European Union, and continuing on with what I called some of the nuts and bolts. We're back with JM, Laura, and Paul to move on to the investment chapter. Something that really sticks out in this investment chapter is them raising the threshold for the net benefit test for European investment. So we're moving up from $1 billion to $1,500,000. Something I'm wondering is what sort of effect is this going to have on attracting FDI from Europe? Are we going to see more companies wanting to acquire Canadian assets as a result of this threshold, or is it not really going to make much of a difference?
I have to say this is one area where I would have liked to see major restructuring in terms of our whole approach to dealing with foreign investment. And I think our Investment Canada Act and the whole net benefit test is so questionable and has probably had a huge chilling effect for years and years and years. Mm-hmm. I know ministers and others keep talking about, well, how many rejections have they actually made, Yeah. It doesn't matter how many rejections. It's everything else. It's a signal. We've got a very, very completely opaque system with about 7 objective criteria. We've added 1 subjective criteria. We've added the security provisions on top of it. It's a nightmare. It's a bureaucratic nightmare that lends itself to all sorts of political ingérence behind the scenes. If I was a serious foreign investor, unless I was desperate to come into Canada for a particular reason, you'd be turned off. And unfortunately, the Europeans weren't able to change that because the Investment Canada Act, all we've got is a little bit of a raising of a threshold. And now, on the dispute settlement process, there's a whole question of how Canada's going to be better aligned with some other countries in terms of the adoption of the convention, but that's another
on the dispute settlement side. Ever since NAFTA Chapter 11, this has really galvanized a lot of opposition. There are a lot of people who in the country, and I don't think just sort of the civil society left-wing side of the country, who aren't so sure about a foreign corporation being able to sue the Canadian government outside of what we think is a pretty effective Canadian judicial system. You have countries like Australia who are in the Trans-Pacific Partnership negotiations, don't want any part of it. If you look at the summary they tabled, they said they've learned from the experience, which I think is interesting language. They said they're going to get rid of frivolous suits, that kind of thing. Do we really still need this? I mean, a Canada-EU relationship is quite mature. We're not talking about a small African country where you might not have a predictable system of dispute settlement.
I think there's 2 ways of looking at it. The one way of looking at it is this going to be a template agreement that Canada moves forward with and uses in its subsequent agreement with all sorts of other countries? Because that's what we did with the NAFTA. After the 1994 NAFTA, we just basically took that and photocopied it with variations in our agreements with other countries. So if this is now going to be the template for what Canada does in trade agreements, then maybe we need to retain investor state, maybe a gradual moving from threshold levels for investment review is a more prudent way to go rather than a very sharp change. At the same time, we have to look at what the risk involved in, and with the European Union, the risk is very, very, very low. As you say, we're not talking about high-risk, inexperienced trading nations. We're talking about the European Union. So if having any sort of foreign investment review situation provides a chilling effect towards investors, then we should rethink that. We're one of the few countries in the world that actually does a foreign investment review for anything other than security in a few strategic sectors. And on investor state, it's never killed anybody. Canada's been able to use it more or less successfully from the NAFTA, so we've had it for several years now. But has it actually paid off for us either? I'm not sure that the costs of it in terms of protests and civil society and lack of understanding, generating opposition to it, I'm not sure that really outweighs any benefits we've ever had. And again, as you said, BJ, we've got opportunities to settle disputes elsewhere.
But from a business perspective, being able to, take legal action against a government who might not be respecting the agreement. I think from a business perspective, it's certainly appreciated. Like I was recently talking to someone about the agreement on internal trade, and that's one of the issues is the enforcement mechanism. You need to convince your government to take up a legal action, which has a further step in the process. I think one issue that governments are going to have to figure out around this dispute settlement mechanism is what if because the provinces have a lot at stake in these agreements and might actually not respect their obligations, and the federal government's the one on the hook for that. And we've seen that in the case of Newfoundland, for example. Yeah. So I think that's something that's going to have to be resolved between Ottawa and the provinces at some point. That also Ottawa has the obligation almost to get it. I mean, they're the ones that are signing the treaty. I think on investment, Paul, what you said, I think makes a lot of sense. In the world of investment, perception equals reality, and I think that as much as our government can say, well, it's only been a few cases where we've turned down acquisitions. I think the perception out there, the more you talk to foreign investors and the global business community, is the perception that Canada wants foreign investment, but telecommunications, not so much. In this other sector, not so much. And so the perception out there is like, Canada's kind of a you want to do an acquisition in Canada, we're not quite sure it's going to work out. And unfortunately, oftentimes what perception becomes reality in the world of investment. So people make their decisions based on those perceptions, and that's what I think I would have liked CETA to go a little bit further in changing those perceptions.
Okay. Yeah, I often find it funny that you'll have opponents in sort of the business community on the same side saying it's an opaque process. We don't know how it works. One side probably not wanting as much foreign investment, and the other side wanting a lot more. Yeah. How could they actually change this? Does it just have to be scrapped altogether? Because we know that's not really realistic either. They need that escape clause for situations when it's just too politically sensitive for them to let something
shouldn't
pass.
Be. I mean, where capital is coming from really shouldn't in itself be the issue. I mean, it's how capital behaves once it's invested and established in a country that's important, and that doesn't change. But a country should really be able to identify beyond sort of national security, where it's understood that will trump any other concerns in Australia and other countries is quite clear. And you can establish a bit of a jurisprudence around cases where a country's national security trumps whatever investment possibilities may come in. But in fairness, I think countries should strive to try and identify strategic or very sensitive sectors and just make that public. And I think you'd find that obviously a certain overlap amongst a lot of other countries. There may be some things that are completely irrational from other countries' point of view. But the point is you make that very clear and public that that's sort of sacred for us. So that lentils in India is sacred.
Right.
For rice traditionally in Japan was sacred for all sorts of very sound social reasons. And the rest of the world knows that. But for the rest, you're just capital flowing in, wanting to invest in a country. And that's the approach that we have to take in Canada.
What's most critical for business is having certainty. And we can debate what the right policy would be, but I think what's most relevant, what's most important is having more certainty about how we're going to treat foreign investment coming into this country. I think we're getting there, but I think we haven't done all
I have to respectfully somewhat disagree with my colleagues. I'm of two minds on it. I think certainty and transparency are very, very important. It is an opaque process. We have to identify certain key sectors, and that's the thing. What is strategic? Is potash strategic, for example? And the fact that the government could step in against a hostile takeover by BHP Billiton in the Canadian potash case was actually good for Canada, and it was good for Saskatchewan, and it was good for provincial interests. May not have been good for certain shareholder groups, but because we are a smaller economy in a world full of piranhas, I don't want to throw out the opportunity for government to step in from time to time and say, hey, wait a minute, this sort of an acquisition or investment may violate our public policy objective.
And I guess that's sort of the problem I have when we ask for more clarity. How clear can we get? At a certain point, there has to be.
BJ. See, that's the point. We should state that in advance. People don't know about our energy sources. We have lots of energy sources in this country. Most countries would probably declare them to be strategic if they're especially just dependent on one or two. But like what is strategic in terms of our energy sources? In terms of oil and gas, we've been prepared to sell it out. We don't have a national policy on that front. So it's sending these mixed signals out to the rest of the world that's so harmful.
And we also still need to be very, very vigilant on investment by state-owned enterprises, investment that affect national security. And I'm not sure, maybe we do, but I'm not sure that Canada has really the capacity to effectively monitor that kind of investment.
Yeah, interesting on that point, because if you look at something like the oil and gas sector, we know how much is in private hands anymore. Not a lot. It seems to be mostly state-controlled, state-owned enterprises. So how do we keep encouraging investment in that if that's the end goal, while sort of being slightly apprehensive about more investment from state-owned enterprises?
I mean, my concern is more. Today is, we're talking about global markets, and unfortunately, we don't have enough Canadian companies that are sort of global champions, like Canadian-based, locally based global champions, and we want to have more of that. And I think in many cases, the issue is with investment is, I think we should be open to foreign investment because it drives economic activity, creates jobs, and all those things. But at the same time, we want our companies to have reciprocal access into other markets. And so I know, like, one area that I've been concerned with in the past was, so it's great to be able to bring investment from all these other countries, but would we be able to reciprocate? Let's say we have a Canadian company that wants to acquire a similar company in the other country. Are we able to do that? And unfortunately, in many cases, Canada's been very open, where Canadian companies have tried to acquire assets abroad. We look at countries like Japan as an example, where I've heard from companies it's a tough market to penetrate. If you want to acquire a Japanese company, it's not. It depends which sector you're in, but right. It's a lot more difficult than the opposite. So I'm just quoting Japan as one example, but we've often seen that with other countries, and I think that's something that should figure out in our policy. Obviously, that's the kind of deal, that's the kind of issue that a trade agreement wants to address, and that's why we need more trade agreements. But I think it's a concern also we should have around investment policy generally.
So finishing up this section, I think there's a consensus here that this didn't do much of anything to clarify the Investment Canada Act process. All it did was, I guess, eliminate some cases where there would be a review.
Mm-hmm. That's right. Although we'll see with that dispute settlement, that's where the language, they're sort of refining all of this, making it a bit speedier, encouraging mediation, trying to get the pools of experts to appear, and so that could all be quite useful, actually.
I'm hoping we see better results on state-owned enterprises and also investor-state dispute settlement in the Trans-Pacific Partnership. I think that's a better milieu to make some progress.